Attorney Truman Fitzgerald here. Have you been accused of a crime? Here are 3 ways we attack your case. Exculpation. Exculpation is the study area of disproving guilt. Many of you may be familiar with the term of art, exculpatory evidence, which is any evidence that tends to disprove guilt and establishes innocence. Before we discuss the 3 distinct categories of defenses, we must define 2 additional terms of art. Mens rea, Latin for a guilty mind. Actus reus, Latin for a guilty act or omission. When discussing omissions, it's important that we point out for an omission to constitute a crime, there must be a legally required duty of a person. Now, for the 3 distinct areas of defenses. Number 1, proving the prosecution didn't prove their case. What an oxymoron. Proving the prosecution didn't prove their case. The 1970 landmark Supreme Court case of Henry Winship established that the prosecution must prove every element of a crime beyond a reasonable doubt. What does that look like in practice? Let's take a look at the state crime of harassment. Harassment is codified as a person commits the crime of harassment if, with intent to harass, annoy, or alarm another person, he or she either strikes, shoves, kicks, or otherwise touches a person or subjects him or her to physical contact, directs abusive or obscene language, or makes an obscene gesture towards another person. Let's attack the state's case of harassment. Directs abusive or obscene language towards another person. It's 2025. Many of the language our grandparents would cringe at is common talk in our society. Pointing out facts that prove this could ultimately disprove the prosecution's case. Or, let's look at the physical contact aspect. Maybe my client had a justified reason for making physical contact, which leads me to the second category, justification. Justification is saying, yes, my client acknowledges her actions. However, her actions were legally permissible. They weren't wrong. Looking at the crime of harassment, yes, my client made physical contact with the alleged victim. However, my client was acting in self-defense. Self-defense is one of the most widely used justification defenses. The key to remembering justification is you're paying attention to the accused actions. Lastly, excuse. The first category, proving the state didn't prove their case, looks at the totality of the entire case. Justification looks at the accused actions. With excuse, we look at the person accused. Maybe the person suffered from a mental disease or defect. Maybe the person wasn't of age that we can hold them legally responsible for their actions. Maybe the person suffered from duress or entrapment. This person wouldn't have committed the crime they are accused of if it wasn't for law enforcement's actions. To recap, category number 1, proving the prosecution didn't prove their case. This defense looks at the totality of the entire case by proving the prosecution didn't prove either of the elements required. 2, justification looks at the accused actions. And 3, excuse looks at the person accused. All 3 of these defenses are distinct, however, they're not mutually exclusive, and all 3 depend heavily on the facts of your case, which is why if you've been accused of a crime in the state of Alabama, you need a criminal defense attorney to tell your We're 1 phone call away. Give us a call at 205-360-0800. Again, that phone number is 360-0800. And always remember this, the law officer Truman Fitzgerald, where law is not a business, law is a lifestyle.